Now we're talking about military contracting, but it brought this up by virtue of bringing in, quote, dealing with alleged contracts to spy. And the specific concerns regarding Martin versus PGA Tour Inc. have to do with mental capacity to make informed decisions based upon being involved with a designation of being mentally ill or mentally incapacitated. And then the discussions about a concept of who would be identified as a superior and who would be identified as a subordinate, and hence what would be appropriate terms regarding disclosure, as well as information being provided to determine and affirm the cognizability of those involved so as to establish and maintain accountability. It says here, when public policy precludes judicial intervention for one, it should also preclude judicial intervention for the other. Judicial intervention would also include acknowledgement of an affirmative defense against accusations of abuse of office or abuse of power, including abuse of access to the judicial system and or ability to use processes or documents or securities involved with the administration of the judicial branch of government for purposes that would not be likewise available to somebody who would otherwise be precluded from judicial intervention. So, suit on a contract or for performance rendered or funds paid under the contract will not lie, and courts should leave the parties to the agreement where they stood on the day they filed suit. Now, which suit in my specific situation would be the one to determine the contract relationship? This specific case was adjudged, determined at the level of the Supreme Court of the United States after I had been declared to be mentally ill, and also after I had first encountered the only time I've ever been provided with legal assistance, which was in an alleged proceeding concerning getting identified as being disabled for the purposes of being put on Social Security disability insurance to receive monthly supplemental income and to apply for other benefits associated with being identified as mentally disabled. But the opinion was delivered before the verdict in that specific case regarding my Social Security was decided. And what was decided in either January or February, somewhere between February and March of 2011, was that at that time I was not eligible to be identified as being mentally ill in order to be identified as disabled so that I could receive monthly supplemental income from Social Security. But it had been determined that the 2 years prior to the judgment, which would have included the year I was in San Francisco, but also the year following my participation in an electoral campaign to have somebody elected to public office, that I was disabled enough to be compensated for the work I had been, for the income I had been deprived of because I was too disabled to work. So it was a form of compensation for lost wages because it had been determined I had a disability. But at the time, I did not qualify to be identified or determined to be disabled. Now, the option was presented to me that I could appeal, and that in appealing, I could potentially demonstrate or argue that I was in fact mentally disabled and that I needed to be given permanent Social Security income. And at that time, I said, I do not want to pursue an appeal. I will deal with the results as it is now. And then I moved forward. So if you're talking, in my case, about the original suit, there was a 2-year period Social Security had determined I was disabled too disabled to be able to work in a manner that would allow me to earn wages to support myself. But there was no justification for identifying me as permanently mentally disabled at the time of the verdict. So that leaves me to believe that at if you follow the premises of this case, what it means is I've never actually been determined to be somebody that is mentally ill. Somebody determined I had been too disabled to be able to work and receive wages for 2 years, but after a point in time determined I was not legally qualified to say I was disabled for the purposes of being able to receive government support for my disability. That means to me, the federal government and Social Security disability insurance did not acknowledge I was mentally ill to the point where I was considered to be disabled or to be mentally incapacitated to a point that I would legally qualify as disabled. Now, my lawyer did not explain it to me like this at the time. My lawyer should have explained it like this to me at the time. I did not. Then the suit would become, well, in 2017. What was the terms of me filing suit at that time? It's on the record. I alleged a pattern of racketeering activity connected with violation of policy regarding provision of funding from the government connected to federal appropriations for services that were supposed to provide health care or things that would legally qualify as health care, including that had policies connected to the appropriate prescription and distribution of controlled substances that I argued should be considered dangerous drugs, specifically because their intent is to alter behavior in order to habituate people to patterns of behavior, and hence the intention and the execution of efforts to compel and or extort people into to cooperating with illegal access to and distribution of dangerous drugs, attended with all the other things against policy and that were illegal that one was required to engage in, was what the pattern of attempted habituation was. That was where I was at the time. And what has happened since? Well, what has happened since is somebody else denied me my rights to due process without describing why or discussing why, and used my efforts for other purposes that do not at this point have an acknowledgement of the legal basis or justifications. Hence, it provides even more evidence to the original allegations. And if we're talking about default, we are more than 3 years on most of them, and in some cases more than 4 years, coming up on 5 years, on major matters specifically connected to what had happened before I filed suit, and instead attempted to go through the appropriate process for reporting them in the context they were. And if that is understood from a perspective of identifying a potential identification of an argument concerning superior knowledge, i.e., somebody in a superior position based not only upon a command structure, but also the responsibility they have for those who are subordinate to them, then I can understand going all the way back to when I first returned to the United States, that there was a situation wherein an argument concerning superior knowledge and the understanding of who had responsibility for matters at hand at that time had already set a specific stage by the time I was in Chicago, and for instance, attempting to contact members of Congress with my concerns and request that they investigate a specific financial institution in connection with members of public office that had been responsible for crimes in other countries that reflected on the safety and well being of the people within the United States. Well, here is the situation also. Government suggests at the time of suit, petitioners had dot dot dot. The first suit in Texas in which I was involved would have been the suit connected to the actual provision of the order of protective custody that identified the hearing for use of restraint as well as the hearing to challenge the order for emergency detention. So that would have been the government, i.e., the state of Texas, or in this case, Harris County Probate Court, engaging me in a suit to identify conditions that would allow for an impugnment of my character in defaming my efforts to report on child abuse and fraud to mandated reporters.